On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, let's get right to it. The first thing, and I know farmers and ranchers are definitely familiar with this, the Charitable Remainder Annuity Trust. And, well, your ability, or maybe not your ability, to use that as a tax and estate planning technique. And I guess in this case, Roger, what we're going to talk about is how not to use a charitable remainder trust.
Yeah, unfortunately, and this has hit some farm families pretty rough in terms of losing all of the tax benefits that they thought they were going to get by utilizing a charitable remainder annuity trust, or a CRAT, and getting penalties tacked on top for getting involved with a tax marketing scheme that is completely fraudulent and that the Department of Justice is currently prosecuting the people involved. We'll get to that in a bit. But the mechanics of a charitable remainder trust and the technique itself can be very, very beneficial. What you do, and we tend to recommend this to people that are in their last year of farming. So they probably have utilized another common tax technique, and that's a deferred payment contract. So from the previous year, they deferred their crop income or their livestock sale income by contract into the next year. And farmers can do that. Farmers are allowed to do that by using deferred payment contracts, and the deferral is on a contract-by-contract basis. So maybe the best technique for many people is to utilize multiple contracts, one for a wheat crop, one for a bean crop, one for a corn crop, for example, another one for livestock. Then take a look at what your tax position is as you come down to the end of the year before you have to file. If you file by March 1, kind of make a determination along with your tax advisor as to whether you want to pull some of that income that you were going to defer back into the year of sale. And you can do that on a contract-by-contract basis. But if you only have one contract that you've sold everything under on a deferred basis, it's an all-or-nothing proposition. You either pull it all back in or you defer it all. So that's why we recommend multiple contracts, which gives you more flexibility from a tax planning standpoint. And so you're retiring from farming. You've deferred last year into this year. Now this is going to be your last crop. You can't defer that one because you won't be engaged in the trader business of farming. So you're going to get a pile up of income in that last year. Well, that's where the charitable remainder trust can come into play. Instead of selling that last crop and incurring not only the income tax on it, but also the self-employment tax on top of that. The idea is to transfer it to a qualified charitable remainder annuity trust, and that transfer is not taxable because it's a transfer, it's not a sale. Then the trust sells the property transferred to it, whether it's grain, whether it's livestock, whether it's land, which funds an annuity back to the farmer. And that might be set up for a term of years, or for the rest of the farmer's life, and there are particular rules that IRS has for determining how that annuity stream gets structured. And then there is an amount that's remaining in the trust at the end of the annuity that goes to charity. So you get a charitable deduction for that. That's valued up front based on IRS tables. So the whole technique is avoid self-employment tax, have your income taxed back to you over a year's as a stream of income, so it's basically an installment sale. And so I don't have the income taxed all in 1 year. I spread that out, hopefully in lower tax brackets, and I get a charitable deduction. If it's done right, it'll work beautifully for many people. But that didn't happen in these recent cases, Greg.
Yeah, and the case, or a couple of cases you're looking at, well, one, as a matter of fact, it was this couple that they read an ad that had been published in an ag journal, so to speak, concerning the capital gains, or talking about the CRATs.
Yeah, and now the Department of Justice has revealed what farm magazine that was, and it was the High Plains Midwest Ag Journal. And so I don't know if that's the version of the High Plains Journal we get in this part of the country, or whether they have regional versions of that. Maybe you know that. I don't know whether that's the general one or whether that's a specific one that goes to certain parts of the area. But the farmers involved in this were, in the initial case, were from Indiana. And the farmers involved in the case that just recently came out, which was a follow-up case, same outfit, pushing the same ad and doing the same setup, they were out of Iowa. So I don't know if that was a regional publication that goes certain ways, but it was an ad that was put in the classified section, excuse me, and it had a couple of headlines on it. It said capital gains taxes eliminated, inheritance taxes eliminated, and it also said, after saying those, maintain 100% control of your asset. Now, that I don't know how this operates in the farm print media world, but when you see something that says you're going to eliminate capital gains tax, you're going to eliminate inheritance tax, and yet still retain 100% control of your assets, that should set off bells and whistles. That's not possible. To retain control and avoid inheritance-related taxes and capital gain taxes. That doesn't work. But people saw the ad, they called the number, and what they get is an outfit out of Iowa and Missouri that was pushing the concept with a CPA firm, a one-person CPA firm in Columbia, Missouri, with attorneys involved on this that were doing the drafting work that were in Minnesota and Alabama. The Alabama attorneys were serving as the trustees. So this was all a canned job. And they put these together, and they were setting it up, telling the farmers that, well, when you transfer your crops, and the Indiana farmers transferred a soybean crop and a corn crop into two separate crats. And you have to do two in that situation, because once you create a crat and fund it, you can't add additional things to it. And so they did two. And the idea, what the CPA firm was giving them, the idea was that, well, the transfer of your property into the trust, in this instance it was crops, was basically a purchase by the trust of the crop, giving it an income tax basis equal to the value of the crop, such that the income stream coming back to you when the trust then sells the property is completely tax-free. That's completely wrong. That is not the case. That's not a sale to the trust. If it is a sale to the trust, then you have to file a Schedule F to report the income. Of course, they didn't do that. And the other kicker in this, Greg, what people need to realize is when you transfer ordinary income property into the trust, such as a crop, and you don't have an income tax basis in it because you raised that crop and you've already deducted the cost of raising the crop, you can't claim a charitable deduction, because you can never claim a charitable deduction that exceeds your income tax basis in the property that's contributed to the charity. So they tried, again, the setup was, well, you're going to get a nice charitable deduction. Well, no, you can't, because you put the wrong type of property into the trust to generate a charitable deduction. And the Iowa farmers in the subsequent case put a hog setup in there. They had hog buildings and the whole hog setup in there. That had been fully depreciated out by utilizing fast methods of depreciation. Now, that triggers another rule. You would normally be able to have that tax, that income stream coming back to you on the contribution of that type of property at lower capital gain rates. But there's another rule. When that property is depreciated, it triggers ordinary income recapture, which is fully taxable to the individual at ordinary income tax rate. So they blew the capital gain issue. They also blew the charitable deduction issue because they had other property going in that they couldn't claim a charitable deduction on, and they did. And the whole thing just capsized on all these farmers, these two different families. And actually, in the second case, there were three branches of the same family, and I'm just talking about the one that contributed the farm property in northwest Iowa. And none of this worked. Department of Justice gets involved. They're prosecuting the attorney the CPA out of Columbia, Missouri, the individuals from Iowa and Missouri that were pushing the life insurance, which was also part of this deal that was being sold to the farmers that bought the crat, because the insurance was funding the annuity stream back to the farmers. And they're prosecuting the attorneys in Minnesota and Alabama that were engaged in this whole process, too. This is an absolute nightmare, all stemming from the ad that ran in that High Plains Journal, Midwest Ag Journal.
Simple math on my part here, Roger. This is very complex, and it obviously went way past complex with the situation that they're in. Thus, though, simply getting sound advice from the right people in this case would have been the, I won't say solution, but would have been the angle that needed to happen for these families?
Yeah, and Greg, that is so difficult for farmers because these people sound so convincing. They really sell this stuff. They are very good at it. They'll cite code at you. They'll throw code sections out, and it's very difficult for somebody to pick through this. So the advice here is always get a second opinion. But a lot of times farmers don't understand that there's even a need for a second opinion because it is presented as so clear-cut that they just cannot see that. And it's just unfortunate. And I go back to the ad being placed in the journal. I wish there was a way that there was some type of screening that could be done, or at least some type of acknowledgement that, look, is it really true that I can avoid taxes and at the same time maintain 100% control of my asset? A light should go on in the print media that, well, wait a minute, maybe we better get on our end. We better have somebody check the veracity of that type of an ad out. But as I understand, I don't think the print media world or even any type of media operates that way, and it's a real problem, and it's just unfortunate for these farmers. I have talked personally with the Indiana farmer on this, and he's embarrassed. He got snookered. He understands it now, and he's tied up. That thing got tied up in litigation. He's lost a bunch of money. He lost the charitable deduction, got hit with penalties, and it's just a sad, sordid tale. Hopefully the Department of Justice will get all of this sorted out, and these people are going to pay the price for what they've done.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And Roger, talking about, in this case specifically, something that is in the Farm Bill, that is called the Farm Products Rule. But in this case, in trying to selling collateralized ag products, this specific case involves racehorses and the breeding rights. Are they an agricultural commodity? And this is not just an ordinary racehorse either.
No, this stable contained the 2015 Triple Crown winner, American Pharoah, and some people may recall that name. But there was about $30 million involved in terms of the assets in a lawsuit involving $23 million of that. And what the issue here is, Greg, back in the 1985 Farm Bill, so we go all the way back to the 85 Farm Bill, which also was the where CRP came from. So we're talking about all these modern-day conservation programs. They were in the 85 Farm Bill, so we got to go back almost 40 years. And there was a rule change that was made. Before the 85 Farm Bill, farm products sold by a farmer weren't necessarily acquired free and clear of a prior perfected security interest acquired by that farmer's lender. And a lot of times those goods were collateralized. The farmer had pledged them to a lender to get money, to get loans, to put the crop in the ground, for example, and those crops, the resulting crops, were taken as collateral. And that became a cumbersome rule, and it was confusing. States had different rules on this. So Congress said, we're going to just federalize the rule, and we're going to change it so that a buyer in the ordinary course that buys a farm product from a person engaged in farming does take free and clear of that prior perfected security interest of the farmer's lender. And that's the general rule. Now, there are some nuances to it. But an interesting issue came up when we had a stable in Kentucky that was, they were financed by the plaintiff in the case, and they sold some of their horses, some of these thoroughbred racing horses, and the breeding rights to those horses to a buyer. And the buyer was saying, well, when they get sued, no, I take these free and clear of your perfected security interest because the racehorses and the breeding rights to the racehorses that I bought with those are farm products. and therefore the new rule applies. This federalized rule applies, and you don't look to me as the buyer to make you whole. And they can sell that to me without giving notice to you. You have to look to them to continue to pay on the loan. But the buyer is saying, I'm in the clear on this. And so it was a really interesting issue, Greg. And the question was whether a racehorse is a farm product.
And in the end, you know, as you look through all this as well, a lot of it ends up being what are the rights of the creditors and, of the agricultural products, how important, in this case, no kidding, how important the issue really ends up being, too.
Oh, it's huge because of not only the dollar amount involved in this, but it's instructive in terms of the broad scope of what the definition of a farm product is. And the lender was arguing, now, wait a minute, thoroughbred racehorses are so unique. I mean, this isn't just a car. This is a car. This isn't just a horse. This is the horse of all horses. And therefore, that cannot possibly be a farm product, which is defined as an agricultural commodity. It's an elite product, is what the lender was trying to claim. The court said, no, it's not. A horse is a horse, of course. In that whole line, and they said no. The Congress didn't make any distinction on livestock and horses. They put in with other types of livestock, and including poultry in this. And they said the horse is a horse. It doesn't matter whether it's a thoroughbred racehorse. Now we can look at them, and if you've driven past these stables and these horse farms in Kentucky, for example, these are fabulous machines, is what they are. They're beautiful horses, and they are different. But for this purpose, under the 85 Farm Bill and the way the Kentucky legislature had written its rules to conform to the federal rule, they said, no, we don't make any distinction amongst horses. And you would think, Greg, of any state, if there was one state in the nation that would make a distinction, it would be Kentucky. But they did not do that in this instance. And so these were farm products, and the buyer takes the horses free and clear of the stable's lender's interest in them, as well as the breeding rights. And they said the breeding rights were ag products in their unmanufactured state, which I think is absolutely correct. Breeding rights are not really a horse, but it could become a horse. So it's a farm product in an unmanufactured state, which fit perfectly the definitions in the legislation.
Hey, one other thing we want to talk about, and of course it is a brand new month, but I understand that there are new fees that take effect today that are on borrowers with good credit scores.
Yeah, this is unfortunate. This is terrible. If you've worked all your life to keep your credit score really good, and now you want to take out a home loan, for example, you get to pay an extra $40 a month on for example, a $400,000 mortgage. It's going to cost you more because Fannie Mae and Freddie Mac, they've changed their loan level price adjustment matrix. This is a regulation coming from the Biden administration and the regulatory agencies here, and they're going to use that to subsidize people with lower credit scores. So that's rubbing a lot of people wrong in the Congress. We'll see if Congress will step in and overturn this, but that takes effect today. Now it's on new loans. So if you have an existing loan, it won't increase your payment. This is just on new loans on home borrowers. And we'll see, there's a lot of talk amongst the American Bankers Association. They're upset about it. Other lenders are upset about it, private lenders, as you can imagine, as well as people with good credit scores. They're being punished to subsidize those that don't have good credit scores. And you're right, that takes effect today.
All right, sounds good. Well, Roger, as always, if people, what we discussed today, they can find that on the website and on your blog as well?
They can, and I also share that with the Ag Manager website over at K-State at the Ag Econ Department.
All right, sounds good. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.